appears on behalf of the respondent, Culver Limited. My lady, my lords, this appeal is made from the judgment of Her Honour Judge Melissa Clarke and her decision that Mr. Head had sustained no loss of income in the so-called lost years. The case has generated a lot of written argument, admittedly much of it from the appellant, and extensive citation of authority. But what this appeal is really about, we say, is this. Was the judge right to find that the £27,000 net salary which Mr. Head allocated himself on the advice of his accountants to stay within the low income tax bracket, was that a fair assessment of his loss of earning capacity? Mr. Head was a self-made man who built up from scratch a business which went on to produce an income and a profit in excess of £500,000 per year. And the effect of the judge's finding was that he recovered no loss of earnings in the lost years.
Yes.
We
now,
say
but Mr. Steinberg, the case is listed as application for permission to appeal, followed by appeal if permission is granted. I don't know whether the noise is off again to continue. There's probably not much we can do about them. Our preliminary view is that there is indeed an arguable point which we should consider on its merits. But we think we ought to give Mr. Kent the opportunity to briefly to talk us out of that view if he would like to.
Lord, I'm never sure whether that sort of invitation is one that it's wise to take up, but I will say a few words, if I may, very briefly. My learned friend, in his opening so far, has illustrated the problem. He is complaining about a failure of the judge to assess what the true value of the services was it more than the salary that he was paying himself or the company was paying him? When, as we have sought to point out in the skeleton argument at some length, that simply wasn't the case that was being presented at trial.
But it's not the true value of the services that one's looking at, is it? It's the question of what earnings, as opposed to investment income, he lost. And the judge's finding is that he lost zero.
Yes.
Which on the face of it is surprising.
No, the judge's finding was that he lost something, but because you then deduct the living expenses, the surviving income meant that there was no loss applying ad certain west. So, Lord, it is a different case. It is a completely different case from the one that was quite deliberately presented at trial, both before trial in the pleadings and the schedule, in the opening note, and in the course of opening and closing submissions, as the judge noted correctly. And so for that reason, we say that this is seeking, having lost on the, as it were, the all or nothing approach, which was, you have an income from this company. Sadly, you're not going to be there to enjoy the fruits of it for the life that you would otherwise have had if there hadn't been this tort committed. And that's enough. That was what was being put. And the judge saw exactly what the case that was being presented to her deliberately amounted to, and sought to assist the claimant by saying, well, is there another way of looking at it? And then says, as I recite in the skeleton argument, it was neither evidenced, neither pleaded nor evidenced nor argued that there was this alternative case. So that for that reason, we say that Lady Justice Simler was right in her first reaction to say that this is not an arguable appeal.
So you say the judge found that he had a loss of earnings, but it was outweighed by his living expenses, therefore his net earnings were and would have been zero.
Yes, to elaborate slightly on that, what the judge said was that the distinction is not between earned income and capital income. It's a question of what is lost. That is the point she makes, I think, at paragraph 70 of her judgment. Where she says, I agree that whether a focus on earned income and income derived from capital assets in a true assessment of losses in the lost years will be fact-specific as this case demonstrates. As I've set out above, in my judgment, the real distinction being drawn by Mr. Justice McCulloch in Adset and West is not between earned income and income from capital, but from income which is lost on death and income which survives on death. And that's the distinction that Mr. Justice McCulloch was making. And it's the distinction which this judge correctly made on the evidence before her. That's why we laboured to say, and acknowledged in the submissions before the judge, that if the claimants had put forward a diminution in profitability of the company because of the absence of Mr. Head from the management of the company, then that would demonstrate, even though it would be a loss of dividend income, a recoverable loss, because it would be a loss in the lost years. But that was expressly eschewed as a method of approaching the matter.
As a matter of law, the lost years claim is not what the company has lost.
No.
It's what the individual or the estate has lost.
Yes. So the estate, I mean, if one takes the extreme example is an estate consisting of a portfolio of shares, and there's no loss, even though the victim is not able to enjoy that income. It continues despite his premature death. At the other extreme is the one-man band, the window cleaner, who is advised to incorporate his business for tax purposes and takes all his income as dividend. The whole lot is lost, even though you could regard it strictly as capital, as income from capital and shares in his company. And this was a case where it was, the question did arise, well, is this a hybrid? And the answer came back from the claimant's side that we're not interested in, that's not a relevant question. This is a company that he set up, and therefore it's all his, which ignores the fact that the way in which businesses work is that once you start off, it's all your labour, they grow and grow and grow, and then it gains its own ability to levitate, as it were, its escape velocity, and it continues to a greater or lesser extent on the basis of the income which is derives from the capital employed in the business, the employees, and goodwill, and so on. And so it continues. And our point was simply that what the claimant can't do in a case like this is say, well, that sort of consideration is irrelevant, whether this is a company that will and can continue.
You say, in short, that Mr. Head still owned his shares, which entitled him to a future dividend flow.
Yes.
And the company was going to continue to be profitable, so the dividends would continue. And that there was no attempt by the claimant to quantify any reduction in dividend flow as a result of short-term difficulties while Mr. Head's sons took over the business. Is that
That's correct.
Your case?
My lord, exactly. And the picket line of authority is doing one thing and one thing only. It set aside Oliver and Ashman, which said, well, someone who's losing earnings as a result of an injury, has the curtain come down at the date when he's expected to die as a result of the injury? And that, House of Lords said, that can't be right, because his loss continues. But the predicate is that he's losing earnings as a result of the injury. And on the claimant's case, as presented, it may be that a different case is now attempted to be presented to your lordships. As presented, the claimant's case was that if you had two identical individuals with identical injuries, but one has his life shortened and one doesn't, both of them unable to carry on at work because of the injury, and therefore having to retire from their business, but both having businesses which survive, the one who has his life shortened actually has a bigger claim than the one who doesn't, because the one whose life isn't shortened will present a loss of earnings claim in a conventional way based upon what his inability to attend to his business has caused, what loss has been caused by his inability to attend to the business. Well, obviously, if this were just a hearing on permission to appeal, I would elaborate rather more than I have done, but I don't want to trespass too far on my own friend's time.
No, quite. Right. We'll just rise for a minute. Mr. Steinberg, we shall obviously want to hear from you what your answers are to the points which Mr. Kent has just made, but we think this is a case of permission and simply hear the appeal on its merits, hearing from both sides.
I'm grateful. So, my lord, we say that the judge was wrong because despite purporting to follow the decision of this court in the case of Warden Newell's and asking herself, what is the real loss? Her answer relied solely on how the income had been classified or categorised for accountancy purposes. My lord, the background was this. Mr. Head was the founder and managing director of EMSL. Together with Mrs. Head, they owned 90% of the shares in the business, and their two sons, Aaron and Dale, who both worked in the business, held the remaining 10%. It was successful, and with Mr. Head at the helm, consistently made a profit in excess of £500,000. Mr. Head took some of the profit as salary. This was up to, but never beyond, the threshold for higher income tax. He extracted some in the form of dividend payments, and he retained a substantial amount within the business. Mrs. Head was paid a similar salary. In March 2018, Mr. Head contracted malignant mesothelioma. His condition deteriorated fairly rapidly. Nonetheless, during that period, he continued to work full-time, save for a short period when he was undergoing chemotherapy. And he maintained his role in the business throughout and up until the date of the trial. He was cross-examined about the prospects of the business and his customers. And he consistently spoke, one can see from the transcript, he consistently spoke about his continuing role, his presence, his contacts. He seemingly found it very difficult to picture this business without him. He intended to keep working as long as possible and deliberately avoided finding out about his life expectancy, such that he asked not to see medical evidence on that point. Now, the judge accepted Mr. Head's undisputed evidence that he would never actually have retired from the business. His plan was to work full-time to the age of 65 and then gradually reduce down. And as he did so, he would distribute the shares and his income would subside. And the pleaded claim assumed that as he did so, as he reduced his hours in the years to come, there would have been a commensurate decline in both his shareholding and the income he drew from the business. The case was issued in September 2018, and it was managed under the expedited proceedings of Practice Direction 3 for mesothelioma claims, leading quickly to a trial in April 2019. Mr. Head sadly succumbed to the disease and he died in November 2019, some after. And the claim and the appeal is now maintained by Mrs. Head, his widow. So Mr. Head sought to recover the income he derived from the business, which he contended would be extinguished for him by his death. And that part of the claim, which spanned a period of more than 20 years, i.e. the rest of his anticipated working life, amounted to something in excess of £4 million on the pleaded claim at its highest. The judge's findings of fact, which aren't seriously challenged at all by either party, included the following 5 points, if I may. And they all appear, my lords, my lady, in the judgment at tab 9 of the appeal bundle. Firstly, that Mr. Head was the driving of the business. That's paragraphs 37, the reference is page 97, and paragraph 87, 109, which he built up from scratch. He made all the contacts, and he is the force behind everything. Also paragraph 37. Secondly, he controlled 90% of the shares. And as the judge said at paragraph 87, the company is him. Thirdly, the allocation and extraction of the profits by way of salary and dividend was Mr. Head's decision, based on advice from his accountant. And if that advice had changed, he would have followed it. That's paragraph 87, tab 9, page 109. Fourthly, that Mrs. Head was, in effect, a nominee shareholder. And that appears, my lady, my lords, at paragraphs 90 to 91 of the judgment. That is page 109, 110. The allocation of shares as between Mr. and Mrs. Head was designed to minimise their tax liabilities, paragraph 88, and similarly for tax reasons, Mrs. Head's actual earnings from EMSL were greater than the strict commercial value of her services, paragraph 96. And fifthly, Mr. Head's decision to retain profits within the business was effectively a method of saving. That's paragraph 106 and appears at tab 9 at page 112. My lords, the judge's overall conclusion is expressed in paragraph 11 of the judgment. And could I just briefly take your lordship's ladyship to that?
Sorry, was that
paragraph
which
11.
was your fifth point?
My fifth point, my lord, was Mr. Head's decision to retain profits within the business was a method of saving.
Yep.
So with that in mind, may I just turn to tab 9 in the judgment itself?
Yes.
And paragraph 11. It appears at page 94. To paraphrase, the judge held, point 1, that the profits from EMSL would not be diminished after Mr. Head's death, and therefore, point 2, that Mr. Head's dividend income would survive his death. Now, we submit that point 1 was based on a misunderstanding of the key evidence, and I hope to come to that in a moment. But further, and in any event, point 2 wasn't a necessary consequence. There is, of course, a relationship between the two, in the sense that the business was the source of Mr. Head's income. And so for this reason, the accountants started their exercise by considering the but-for prospects of EMSL in order to create what was a baseline for that assessment. But we say these points weren't the same, and by aligning the two, points 1 and 2, it illustrates another slightly different mistake in the approach, which was namely the judge's failure to consider Mr. Head's personal loss. We also say that there were in fact 3 questions for the judge to answer. Firstly, what profits would EMSL have produced but for the tort? Secondly, what income would Mr. Head himself have derived from EMSL but for the tort? And this was necessarily limited by the answer to question 1. And those questions,
Just
beg your pardon, my lord.
slow down, Mr.
beg your
Steinberg.
pardon.
I'd like to write these three down,
Beg your pardon.
unless you're reading from your skeleton. 1, what profits would EMSL for the tort?
Yes.
2,
2, what income would Mr. Head himself have derived from EMSL, but for the tort?
yes.
Now we say, of course, that point 2 is necessarily confined and constrained by point 1. He can't derive more than the business made. But those two questions were addressed by the expert accountants, and the judge made findings in answer to both. And those findings are largely unchallenged. And then the final question, point 3, was this: to what extent would Mr. Head's income, and I stress here Mr. Head rather than EMSL, to what extent was his own income and earning capacity diminished as a result of his anticipated premature death? My lords, my lady, can I briefly turn to the legal principles underlying the lost years claim? I don't propose to say much because there's not much in contention between the parties. But at paragraphs 45 to 51 of the judgment, that's at pages 99 to 100 in tab 9, the judge set out a concise summary of the basic legal principles underpinning the nature of the lost years claim. It wasn't controversial between the parties, and we respectfully agree with that. The judge also considered, at paragraph 62, the decision of Mr. Justice McCulloch in the case of Adset and West, and on the basis of that decision held that what she had to decide was what the claimant would actually lose as a result of his death. That's paragraph 66, and also, as my learned friend has taken you to, paragraph 70, where she repeats that point. And pages 104 to 105. Now, the claimant's primary case at trial was precisely in these terms. And we say, contrary to my learned friend's submission, it hasn't changed. But what the claimant contended at trial and before this court was that the income he derived to derive from the business was not just the salary component. It was effectively everything that he took from the business or could have taken. The claimant's alternative case, the secondary case, was that Adset and West was wrongly decided on the basis, A, that there should be no distinction between earned income and investment income, and B, the claimant would be entitled to recover his whole income purely on the standalone basis that he would not be around to enjoy it and dispose of it as he chose. On the facts of the case, at least from the claimant's perspective, the occasion for the alternative argument, we say, didn't arise. And on the basis that the claimant's income represented his work-related earnings from the business. And my lords and my lady, as a result, that alternative case wasn't pursued at trial, and indeed isn't pursued before this court.
That Adset and West was wrongly decided.
Oh, no.
Right.
Perhaps we'll save it for another day. So the appellant doesn't challenge the judge's analysis of the authorities or on the whole her identification of the legal issue. The complaint is how those principles were applied in this case and how the judge approached the key question. And we say that there were two distinct categories of error. First, there was a mistake of fact, and we say the judge misunderstood the meaning and purpose of the expert accountancy. And secondly, we say there was a series of errors which led to the judge's failure to assess what Mr. Head had really lost. And the grounds of appeal, which are on the appeal bundle, tab 1, at page 12, all arise out of those contended mistakes. And there is a large degree of overlap between them. We accept that. The appellant's case may be encapsulated by the following 6 propositions, which I hope to develop in turn.
Right. Again,
Lots of different points.
If you're going to give us
Another
6
list.
points, then take them slowly.
Firstly is the central error. We say the judge misunderstood the core premise of the expert accountancy evidence. That's proposition 1. Proposition 2. As a consequence of this error, the judge misunderstood the basis of the claimant's case. Proposition 3, the effect of the judge's ruling was that the claimant was wrongly held to have lost only his director's salary. Proposition 4, the correct approach, following Ward and Yules, was to consider and ascertain the real loss, i.e. to focus on the reality rather than the categories. Proposition 5 is that the key question is what Mr. Head would personally lose, and an appropriate test to determine that is whether that income or that earning capacity can be given away by a simple gift or transfer. And finally, Proposition 6, by reference to this test, the judge should have held that the claimant had lost his income and the retained profits. If the court accepts Proposition 1, we say the judge's decision is fatally undermined, and on that basis alone cannot stand. But the remaining proposition and the grounds of appeal which follow, we say are freestanding, and if accepted by this court, require a reappraisal of the damages. May I turn then to Proposition 1 and seek to develop that point? It's also ground 1, and it's what we've described in various places as the central error. In essence, the judge misunderstood the core premise of the expert opinion. The judge assumed that the expert's but-for projections of the company profit made on the assumption that Mr. Head would still be alive and in charge. She assumed that they were in fact projections of the actually anticipated performance, taking into account the effect of his death. Now, the mistake was so fundamental, we say, that it appears at first sight inherently improbable, and there may be a temptation to assume that there is some other explanation. But we say there was no ambiguity, and it's clear on the face of the judgment. Now, the respondent doesn't accept this, and so to make this good submission, to make good this submission, I perhaps have to show 2 things. First, the nature of the evidence given by the accountants, and secondly, to put it bluntly, that the judge thought it said something else. So, my lord, first of all, what was the nature and the meaning of the expert evidence? The experts themselves were both simply asked to value the lost years claim. And this is a well-trodden path. It was clearly understood, we say, in this case by 2 experienced experts. There is no doubt, we say, about what they thought, what they did, and what they thought they were doing. The first stage, necessarily, in this process is for the experts to agree, if they can, what income the claimant, what the claimant's income would have been but for the tort and the injury he sustained. This was a baseline from which it could be measured, and this was what precisely we say the experts were seeking to do in their projections. Indeed, it's difficult to see what else they could have been. The defendant's accountant, Richard Forth, described his method in those terms. For example, I don't propose to take the court to it, but it's
I think maybe at least you should show us where to find
Yes.
it?
Well, it's in the supplementary bundle, tab 11. Paragraph 3.4, which appears at page 293.
Yes.
And 3.4a we say is fairly clear. For the claimant,
He does have, however, at 6.7 a reservation as to whether that is the appropriate method when the shareholding will be inherited and an income stream will continue to flow.
my lord, yes, he was adverting to the Adset and West point. But the basic premise, the starting point, was a but-for projection of what the company would do. He then queried whether, as a matter of law, that was recoverable.
Yes.
We say that's a matter for the court, not for the accountant.
Yes.
But that was the starting point. My lords, James and my lady, James Stanbury, the accountant for the claimant, confirmed in his evidence that that was the limit of his projections. And for reference, that's in the transcript in the supplementary bundle, tab 1 at page 45. The bottom of the page between G and H in response to questions from my learned friend. The underlying but-for premise of these projections is immediately apparent in the way we say both the experts treated the income that Mr. Head would have drawn from the business. They each assumed in their calculations that his shareholding and income would have declined as he reduced his role in the business. And again, my lords, for reference, I don't propose to take you to it, but for James Stanbury, it can be found at page 259 of the supplementary bundle. It's paragraph 3. And for Richard Forth, it is page 303 of the supplementary bundle, paragraphs 4.23 to 4.24.
What was the Stanbury reference?
I beg your pardon. The Stanbury reference is paragraph 4.03. It's the supplementary bundle behind tab 10.
Yes.
And Mr. Forth's is behind tab 11. They're
Thank you.
arranged consequentially. The parties, we say, both understood the position. The respondent's opening note for trial made the point that the treatment of the claimant's income was a legal question, which is a point my Lord Justice Mayles made. And to put this into context, Mr. Forth had estimated that the claimant's loss of income was somewhere between £800,000 and £1.4 million, depending on whether...
He'd estimated that the but-for figure was that.
Yes. He actually described it as the loss, but he raised the query as to whether Adset and West would nullify that. And my learned friend in his opening note made precisely the same point. If I perhaps just take you to that to see how the defendant was putting it at this stage.
Look, can we first
I'm sorry.
quickly look at Mr. Forth's calculation, which
Yes.
I did see. It's page 3.
303.
This is 334 in minute font.
Yes. Well, if it assists the court, we've brought along some A3 versions of those. That would
That would be a great blessing. I speak for myself, if you have those schedules in more legible font, it's fine, but 3, 3, 2, 3 and 4 are very hard going.
Apologies for turning around.
That's all right.
Not sure how to do this. Correct plan.
Yes, I'll ask my judicial assistants. Sam, could you act as usher for these purposes?
Thank you very much. Thank you. Yes, it's.
Thank you, Sam.
Oh yes.
My lady, my lord, schedule 4 is Mr. Forth's projection.
Yes.
And you would see in the column there how the director's salary is presumed to decline.
Yes.
And the dividends too, if you follow that there down to the third row down.
So starting at 172,000 net of tax,
Yes,
and then declining to about 105.
precisely. That's Mr. Forth's projection.
Yes.
Mr. Stranbridge was slightly high, but they took a similar format if the figures were exactly the same.
So they start from a standpoint that the salary is at a steady level, and salary starts going down, and then dividends start at a level, and then that goes down too.
To reflect, we say the declining input.
Yeah.
And, my lady, my lords, Mr. Stanbury took a similar approach. The figures are different, very different, but
And this is on the basis that these are estimates of the dividends he would have paid himself, not left retained in the business as savings.
Mr. Forth made the point.
Lord, I'm not sure that's strictly correct. I think the calculation was based on the assumption that all the profits were distributed.
Yes.
At some point. That was certainly conceded by us, that for the
Yes.
calculation of what the income would have been, it's irrelevant that it would have been retained, apart from an issue of both.
My friend makes a very fair point. Mr. Forth had said that he thought it sensible and reasonable to treat the retained profit as that which Mr. Head could extract. Decisions.
Right.
So,
So this, you say, is Mr. Forth's assessment
Yes.
of the lost earnings. Yes.
yes. But my learned friend, in fairness to him, said that's a legal question and made this point in the opening note trial. And could I just briefly turn to that? It's in the supplementary bundle at tab 4. Page 186. Paragraph 2. It is said roughly halfway down this passage, making a distinction between the projections that Mr. Forth had made and what my learned friend said was the legal position, that both JS and RF's calculations of losses, the latter based on two alternative scenarios. And just as a reminder, the two alternative scenarios were Mrs. Head's income being taken into account or not.
I'm so sorry.
I'm sorry.
I've lost you.
I'm sorry.
Tab 4 in the supplementary.
Tab 4 in the supplementary bundle, I'm referring to the defendant's opening note for the trial.
Yes.
Well, the problem is my paragraph numbering is eccentric.
It certainly seems to be.
Right,
Not a deliberate bias.
Which
first
paragraph number
paragraph
and is it the first time or the second time?
So the second paragraph to page 186.
These differences themselves account.
Exactly.
Okay. Can I read this paragraph? Yes.
Right. So, my lords, I'm not trying to take an inexpensive point. It's simply that the parties were both aware that that was the nature of these projections. We say that there was no doubt. Realistically, there can be no doubt what the experts were trying to do. They were giving but-for projections of what the company would do. And if any doubt remains, we would simply ask your lordships to read the reports from cover to cover, because the point is made in the detail. The next question, therefore, is what did the judge think the reports were saying and what the accountants were saying? We say it's equally clear that the judge read these reports as providing projections of the actual anticipated profits of EMSL and the income that could be derived from it, notwithstanding claimants' anticipated debt. The judge stated this explicitly and repeatedly. They are gathered together, the examples that we give at paragraph 40 of our replacement skeleton argument, which is in tab 3 of the appeal bundle at page 33. But I propose to take them in order that they appear in the judgment and also to put them into context, if I may. The first of these examples is at paragraph 73, and it's in tab 9 of the appeal bundle, starting at page 106. Now, in this passage, the judge was estimating the annual net profits of EMSL. The context was that she was considering the anticipated profits in Mr. Head's absence.
Can we, before we look at paragraph 73,
yes,
can we just look at the bold type in 71?
Yes.
72 is not contentious. Are you content with questions set out at 71?
My lord, yes. We say they don't ask what is the key question, is that what Mr. Head personally will lose, but insofar as they go, we submit they're a reasonable approach.
Right. Paragraph 73.
73, yes. So here the judge was estimating the annual profit of EMSL and in Mr. Head's absence. And she held that it was a successful business and with a very strong financial foundation, and the customers would continue to rely upon it. And over the page 107, she said, "For those reasons, I accept the opinion of the expert forensic accountants that it is more likely than not that the profitability of EML-SL will not diminish following Mr. Head ceasing to be actively involved in the company, and Mr. Head's estate will continue to have the benefit of his income from capital in the form of dividends payable on the shareholding in EMSL." So here the judge is assuming that the experts had agreed two things. Firstly, that EMSL's profitability wouldn't reduce following Mr. Head's death. And secondly, that his estate will continue to have the benefit of that income. My next example is at paragraph 117.
I mean, I understand entirely what you say about the sentence beginning "for these reasons" and what you say was the judge's mistake. But are the first few sentences, is there anything wrong with the first few sentences of that paragraph up until that point?
My Lord, no, that was a fair reflection of the evidence about which we don't complain.
Okay.
We say it leaves open what would have happened in the future, but insofar as Mr. Head was concerned, it was an accurate reflection of the evidence that he kept. So my next example is at paragraph 117, and that appears a bit further on at page 114 in this tab. And
Would you say of the last sentence of 73 that even if that were correct, it's an answer to the wrong question?
oh, precisely. My Lord, that's the core of this appeal.
Sorry, you were then taking us to
Sorry, yes.
117.
117.
Yes.
In this passage, the judge was considering a distinction drawn by my learned friend, one to which he's already alluded today, between Mr. Head's company and a one-man business, where the work would cease and dry up if he were to die. The judge held that that distinction was entirely apt because, as she said, in paragraph 117, and I quote, "I have accepted the forensic accountancy expert's opinion that the profitability of EMSL is likely to continue." If I may, my next example is further down this page in paragraph 121. And it starts on this page, but in this passage, the judge was considering the possibility that the claimant's absence could have an impact on the business and the future dividends. The judge had considered whether this was something for which she could make an award, but decided it wouldn't be appropriate since she held, and this is over the page at Roman 3, it wouldn't be appropriate. And one of the reasons was the experts agree that it's more likely than not that EMSL will maintain its profitability in the future, and I have accepted that opinion. And finally, starting on the same page, paragraph 124, where the judge in this paragraph was considering the claimant's fears about the future for the business once he was dead. She said this, and this is the penultimate line in this page. "I entirely accept that those are real fears, honestly expressed. However, I have accepted on the balance of probabilities the expert shared that EMSL can weather the handover without an adverse impact on its profitability." We say the judge's reading was manifestly wrong, and the respondent has suggested variously that the judge's opinion was a necessary implication from the expert's report, or that it's somehow a question of context, and they can be interpreted in different ways. We say to the contrary, that the context of these passages makes it precisely and absolutely clear what the judge was saying here. And we respectfully submit that the respondent's position on this point is untenable. I'd like to move now to my second proposition, which...
this seems, paragraph 124 seems to be a finding that Mr. Head was, I'm using the word in the financial sense, worthless to the company, that it made absolutely no difference whether he was there or not.
Yes.
And you would say, firstly, that's wrong, and secondly, even if it were right, again, it's an answer to the wrong question.
My lord, yes, and it's also contrary to the judge's other findings.
Yes.
Which is the problem. If I was simply faced with a finding of fact, I may have more difficulty.
She found he was the driving force behind the company.
Very precisely.
And if he's the driving force behind the company, he can't be worthless.
Maybe yes.
Well, one can see that there are companies of a type where by the age of 60 the founder has become a passenger, or sometimes made honorary life president or something like that, but is actually not working for the company, just drawing dividends from shareholding. Fine, in which case the lost year's claim is zero. But you say that is not this case.
That's not this case. He was...
all right. Well, we looked at one. We looked at 124.
Yes.
Yes. All right.
So with permission, I'll move on to my second proposition, which is that as a consequence of the central error, the judge misunderstood the claimant's case. We say it was central to her findings, and it's apparent. It was apparently the basis for the conclusion to which I've taken the court already at paragraph 11. That Mr. Head's premature death would have no impact on the business, the point on which the experts had expressly given no opinion, or B, that the income that Mr. Head could derive from the business. And the judge was under the impression that the claimant's case was that he was entitled to recover his earnings regardless of whether or not they would be lost. This, we say, wasn't helped by the way in which the defendant had characterised, we say mischaracterised, the claimant's primary case. And I'm afraid I'm going to venture back into the eccentric numbering of my learned friend's opening note, which is in the supplementary bundle at tab 4.
Yes.
Between pages 189 and 190. In the one and only paragraph 20, my learned friend and the defendant was considering the possibility that the claim could have been brought in different ways, and he referred to the Blameyer and so on. But over the page at the top of 190, he said this, but that is not how the claimant's case has been presented. His claim proceeds on the basis that he can recover the relevant proportion of income which will not be lost as a result of his premature death. Now, that may or may not be a fair characterisation of the claimant's alternative case, but it isn't an accurate depiction of the primary case. So, for whatever reason, the judge thought that the claimant was seeking to claim income in circumstances where it was agreed that his estate could draw on the same level of income and the same dividend from the business. And that much is evident from paragraph 8 of the judgment, and the way in which the learned judge framed the key question. And may I, jumping around for which I apologise, but paragraph 8 in tab 9 at page 94.
Yes.
The judge held as follows: the issue is this: is it a relevant factor in arriving at the lost years calculation that a significant part of Mr. Head's income, sorry, I beg your pardon, Mr. Head's earnings, namely his dividend income from EMSL shares, is likely to survive his death? The mistake here, we respectfully submit, is that the judge had assumed the very thing that she was being asked to decide, namely the extent to which the dividend income and, in parenthesis, the retained profits would survive his death for his benefit, as the state's benefit. And we submit the judge didn't consider this point in detail because she thought it had been decided for her by the accountancy evidence, by the shared opinion, which we say was no such opinion at all. Accordingly, the foundation of the decision was what we would describe as a catastrophic mistake in both senses of that word. Disastrous. And it's why we say this: if this court accepts the judge made this error, the decision is fatally undermined and must be replaced with something else. Can I move to my third proposition, which is that the effect of the mistake was a ruling that the claimant had only lost his director's salary?
Just really, what do you say the right question would have been to ask at paragraph 8? Because
the right.
as because it, tell me if I've got this wrong. The evidence about what was in fact likely to happen was that the company would continue to be profitable under the management of the defendant's sons, but there might be some unquantified reduction in profitability while they took over and built up the contacts which their father had nurtured.
Yes.
Is that a fair summary of the evidence?
Not quite.
No? All right.
We say the evidence didn't touch upon future prospects. The cross-examination was predicated on the basis that the claimant, Mr. Head, would still be around. My learned friend, I should say in fairness, did approach that question, but the judge's findings, we say, were limited by her understanding to what the business would do in future with Mr. Head in charge. And so the correct question...
But I thought Mr. and Mrs. Head came and gave some additional evidence, not in their witness statement, precisely to the effect that i.e. that their sons didn't have quite the same level of contact with
my Lord, yes. And we say the judge just didn't approach that because she thought that question had been decided. And moreover, we say the right question, so in answer to my Lord's question about paragraph 8, the right question was to what extent would that income survive for the benefit of the claimant or his estate? And we said that it's I was about to say it's a subtly different question. It's not such a subtle difference, actually. It's a very different question. And my lords, I hope to address that.
But do you accept that what my lord was putting to you as a matter of prediction, that really, including from the evidence that Mr. Head gave on commission, and then when he gave evidence at the trial, and when Mrs. Head gave evidence at the trial, that it was predicted that when he died there would be some fall off to begin with, because his sons were not as didn't have the lifetime of experience and contacts and so forth, but the company wouldn't go into a nosedive, and after a period it's likely that its profitability would pick up again. Are you saying that that's wrong, or that it's right but it doesn't lead to the reasoning which the judge adopted?
My lord, I would say it isn't quite right, in the sense that Mr. Head and Mrs. Head were expressing concerns But there was inevitably, as there always will be in this type of case, a good deal of uncertainty. They just didn't really know. They weren't saying, we fear this business is going to go bust within 5 years. In fact, I think Mr. Head said that in terms. I don't think that will happen. He thought his sons were apt and would do their best. But my lord, it is the wrong question. And that's as my lord said. And we say, that is why I describe this question as a red herring. I perhaps retract the awful cliche, but I don't retract the point, because what we're focusing on is what he would lose or what his estate would lose. And we say in the real world, it couldn't produce the same income without him there for the benefit of his shareholding and his interests. I hope that's clear. I'll try to develop that, if I may, in the next couple of propositions. So the third proposition was that the effect of the mistake was the judge's ruling that the claimant had only lost the director's salary. And so, to come back to my lord's question, although we respectfully submit she had identified the right question from Adson or West, it was undone at the final step of her calculation. So to try to explain what happened and where it went wrong, I propose to start at the end of that calculation and show the court the final step. And the mechanics are set out in paragraph 118 of the judgment. So it's back in tab 9 of the appeal bundle, at page 114. And could I perhaps just invite the court to read paragraph 118?
Yes.
So this is the final stage in the assessment, where we say the judge ought to have been considering what would survive, and if necessary, making an apportionment between that which would and that which wouldn't. Instead, the judge appears to have felt herself compelled by what she perceived to be the shared opinion of the experts, to assume it would just be the director's salary. And at Appendix 1 of our skeleton argument, we have actually depicted this calculation in table form. I'm not sure whether it helps, but perhaps I can just take the quant to it.
Page 22.
It's page 47. So the left-hand column of this incredibly thick, bold line necessarily shows all of Mr. Head's sources of income. It includes his net salary of $27,900, his dividend income extracted at 67 or thereabouts, and his retained profit of 105,000. And the penultimate row of text shows how the judge dealt with the living expenses, which was 45% of that which is extracted. And that produced a surplus income in excess of £157,000. And the right-hand column shows the income which the judge deemed to survive for the benefit of Mr. Head's estate. And this includes everything apart from his salary. So the effect of the ruling is that everything in the right-hand side is deemed not to be lost. And that produced a surviving annual income of £172,000, and the conclusion, therefore, that the claimant's estate would be £15,000.
He's better off dead.
Yes.
Salary 27,000, expenses 42,000, therefore claim 0.
Money, yes. It's also apparent that it's based purely on the category of income rather than reality. We say that this is inconsistent, not just with reality, but also with authority. And when I say authority, I mean the decision of this court in Ward and Yules. And my fourth proposition relates to that case and its effect. So proposition 4 is that the correct approach in the light of authority was to ascertain the real loss. And we say in this respect, the decision of this court in Ward and Yules, it's of general importance and also provides a clear guiding principle for the assessment of damages in this type of case. It's at paragraph 11 of the authorities bundle. Sorry, I beg your pardon. Tab 11, not tab 11 of the authorities bundle. The essential facts appear in the head notes. Plaintiff had been exposed to asbestos and he had developed a restrictive lung disease. Not mesothelioma. It was a progressive condition. He brought a claim for loss of earnings. He had been in partnership with a Mr. Eade, and that partnership was used as a vehicle to distribute the profits from 5 companies within their group. They were both married, Mr. Eade and Mr. Ward, and on the advice of their accountants, they had declared to the Inland Revenue that this was a partnership of 4. For his loss of earnings, however, the plaintiff claimed the 50% of the profits that he said were really his. The findings of fact are set out in the judgment of Lord Justice Henry, but could I just pick up one point from his judgment at page 198 and the findings of fact? Page 198, sorry, of the appeal bundle, it's 1724F of the numbering of the report itself. He said the judge found, this is between E and G, the judge found that Mr. Ward had been a healthy, vigorous and successful businessman. He was a workaholic, and the fortunes of all the companies which he owned 50-50 with Mr. Eade depended to a large extent on him, his dynamism, his attention to detail, his personal supervision of the business, and his client base developed through all these qualities. The judge concluded he was a businessman of unusual competence, and his personal skills and commitment were a major factor in the degree of success of the group business. And just pausing for a moment there, we say that the judge could have been talking about Mr. Head. But notwithstanding these findings, the trial judge held that the plaintiff was bound by his declaration to the Inland Revenue and limited his loss of earnings claim to 25% profit of the business due to the existence of a total of 4 partners. And the Court of Appeal, at page 1727 of the report and page 201 in the authorities bundle, held this between G and H. The issue before us can be encapsulated in the question: what was Mr. Ward's real loss of earnings and/or earning capacity? And on this basis, the court allowed the appeal and held that the plaintiff was entitled to the pleaded 50% share. That is the point that we draw from Ward, but my lady, my lords, at this point I'd like to go on a short detour perhaps to deal with the point that's raised by the respondent. In the respondent's notice, the additional point that the judge was wrong to find, as she did at paragraph 93, which is at page 110 of the appeal bundle, that Mr. Head's real loss of earnings was not limited by his 45% shareholding but in reality also included Mrs. Head's share. So we submit that the authorities established that in assessing damages in this type of situation, i.e. where the income is derived from participation in a partnership or from a corporate structure, the court should focus on the underlying reality of the relationship. In essence, this is a subspecies of what we say is the fundamental question. What is the real loss? And on this point, we respectfully say that the judge's reasoning was impeccable. The judge summarised the respondent's submissions at paragraph 86 of the judgment, and that appears at page 108 in tab 9. Moving from 108 to page 109. Perhaps I can invite the court just to read the basic
Yes.
features of the summary.
I've got to paragraph 93.
Oh, I'm sorry, my lord, I was
Yes.
referring to 86.
Right,
Okay, well,
okay.
well.
Yes.
Well, in that case, I'll take this very quickly. We say the judge disposed of this in a series of factual findings. First, that Mrs. Head effectively held the shares as a nominee of her husband. Secondly, that she only had the shareholding because the accountant told us how to do it and I went along with it. Thirdly, if Mr. Head wanted to arrange the shareholding or salaries differently, she would have agreed. That's all from paragraph 90. Fourthly, that Mrs. Head considered herself to be holding the shares at his direction. And fifthly, if Mr. and Mrs. Head had been told of the fact that their Mr. Head's 90% shareholding in the MSL, if she'd been told it had been split differently, it would make a material difference, then they could and would have done so. So at paragraph 92, the judge rejected the defendant's argument that Mr. Head's contributions in the domestic sphere were relevant and ought to be taken into account. And similarly, it made no difference that Mrs. Head was a director, since that was irrelevant to her shareholding. Accordingly, following Warden Newell's, when assessing the loss, the judge treated Mrs. Head's shares as belonging to Mr. Head, and we say that was respectfully perfectly correct and right on the evidence. Now, the respondent doesn't seek to overturn those findings of fact, but instead seeks to distinguish Warden Newell's on the basis that in this case, the court was dealing with a partnership which was terminable at will by any one of the partners, whereas Mrs. Head had an indefeasible right to the shareholding, and the reference for that is paragraph 44, Melonhead Friends Skeleton, Appeal Bundle 4, page 68. So may I therefore take the court back to Warden Newell's and how the case had been put in for the appellant in that case. It's back at tab 11 of the authority bundle. The arguments advanced by the appellant appear at page 200 of the bundle numbering, page 1726 of the report numbering. And between G and H, we can see there at the start of that paragraph that Lord Brennan distinguished Kent and British Railways, a case to which Malone refers, on the basis that the plaintiff's husband had been working as a partner, and he submitted that neither Mrs. Ward nor Mrs. Eade were partners. And then further down, one can see the submissions that the appellant made. First, the court should assess Mr. Ward's actual loss. Secondly, his actual loss should be determined by his half share of the partnership profits, however this may have been treated for tax purposes. Thirdly, the only deduction from Mr. Ward's 50% share should be in respect of any sum which could properly be attributed to his wife's actual services to the partnership, as she did nothing for the partnership. Nothing should be deducted. And fourth, that Mr. Ward and Mr. Eade followed the accountant's advice as to how to treat the partnership income for tax purposes, but did not follow his advice about drawing the partnership and did not intend to create a legal relationship. So that was the way in which the appellant put the case before the Court of Appeal. If I could take the court on to page 1729, which is page 203 of the bundle numbering, beginning with the first paragraph, the end paragraph of page 1729. We can see there that the court rejected the appellant's first submission. And over the page, at the top of page 173, at A, it seems to us that the only realistic finding is that Mrs. Ward was a partner, albeit a sleeping partner. And then, if I move forward in this page, page 1730 to the bottom section, Lord Justice Henry said as follows, that though Mr. Ward, this is between G and H, though Mr. Ward and Mr. Eade made their wives sleeping partners, there was no formal partnership deed entered into between them. Given the informality of the arrangements, this is not surprising, but given that the informality is quite clear that the arrangements between the husbands and wives existed from year to year and were terminable at will, Mr. Ward and Mr. Eade together controlled all of the 5 companies that were passing on management fees. The partnership depended on them totally, and consequently they could have any time terminated any arrangements. So that was the context. But the reasons why the Court of Appeal accepted the appellant's arguments appear in the passage that begins at the bottom of page 204, where Lord Justice Henry said, first, this is the penultimate line, first, we see no reason for assuming that given the acceptance of the sleeping partnership, the four-way division of income was either put forward to the revenue as, or understood by the revenue as an agreement accurately representing the comparative value of each partner's contribution. Then second, short way down, there is no public policy reason for holding that the parties to that division of profits. The apportionment of profits is an internal matter for the partners, which doesn't affect anyone but them and the revenue. And third, the apportionment of profits between the partners is terminable by will year on year. There is no reason to look on it as an advancement for all time of half the profits of the partnership. And fourth, we simply don't accept Mr. Powell's submission that it's simply a matter of the rub of the green. So in the passage that then follows at D, the Court of Appeal through Lord Justice Henry said that if they'd been unconstrained by authority, they would have looked to the reality. And that goes back to the earlier passage I mentioned before, and took your lordships and ladyship to, that the real question is what has actually been lost. And in doing so, in considering the possible authorities, over the page, page 1733, this is paragraph 207, sorry, page 207 of the appeal numbering. The court said this, we have reread Kent and British Railways Board carefully and do not find it in conflict with the conclusion we have reached. There, Sir John May was dealing with a partnership to the success of which both husband and wife contributed. The judge declined to accept the apportionment agreed by the revenue, and in adopting the presumption of equality in default of agreement under section 24 of the Act of 1890, he expressed himself as looking at the reality. We are sure that if the reality of the plaintiff's loss measured by her contribution had been 70%, he would have found for that figure. There is no reason and no power for the judge to trump reality in a personal injury claim by any internal allocation of the division of profits in the partnership, which does not reflect the true value. Moving to the present case, we say that Mrs. Head's shareholding was not terminable at will. Sorry, we say that the defendant's case that Mrs. Head's shareholding was not terminable at will, unlike the partnership, is not the point. There was, as my learned friend has suggested, that was one of the considerations that the court took into account in Warden Eagles, but we say it was merely one of the factors. And it was a step in their reasoning to finding what the real loss was and what the real situation was. It certainly, we submit, wasn't determinative. Mrs. Head's unchallenged evidence was that she would have accepted whatever arrangements her husband had suggested to her. The judge held that, in effect, she was a nominee shareholder. And as with Mr. Ward, Mr. Head could have reorganised his affairs if it had been suggested to him that the legal effect of the arrangement would have been to halve his damages. That was the reality of that situation. Notably, if I can just, one final thing from Warden Neal's, at page 1733, same page G, Lord Justice Henry said this, the reality is that Mr. Ward could and would have reorganised his affairs if it had been suggested to him that the legal effect of his arrangement was to halve the damages, which he would otherwise be entitled. Thankfully, that is not the law, and we...
Sorry,
I beg your pardon, my lord.
It's judgment?
1733, opposite.
Oh yes,
G.
G. Yeah.
We respectfully agree that that can't be the law. And although my learned friend says that the distinguishing factor is the existence of a partnership terminable at will, we say that was merely one of the factors which led the Court of Appeal, in this case, to form the conclusion that the reality was that this was Mr. Ward's loss and not Mrs. Ward's loss. My lords, that's the end of the detour, and we say the judge failed to apply award with the artificial result that the claimant was held to have lost only his salary. And if actually we were to apply what Lord Justice Henry said, if Mr. Head had ignored his accountant's advice and classified all of his earnings as salary, it's difficult to imagine that this case would have been quite so controversial. But the focus on reality, we say, cuts both ways. And so if Mr. Head, in the knowledge of his impending death, had changed his arrangements, knowing that trial was coming up, knowing that he was about to die, had changed his arrangements and taken that year an unsustainable profit from the business, something in excess of £500,000, with a view to maximising the recoverable damages, then that would have been rightfully impugned because it wouldn't be the reality. And so we say this is a situation, applying this guiding principle to look at the reality one can achieve and determine the true loss. Can I move to my fifth proposition, that the appropriate test applying Adset and West is to assess what has been lost, and where it's not demarcated, obviously it may be tested by asking whether the source of the income can be given away by a simple gift or transfer. At trial, most of the legal attention was focused on the decision in Adset and West, the first instance decision of Mr. Justice McCulloch. As I have said, we respectfully agree with the judge's analysis of that case and the ratio that followed, which is that the claimant in the lost years, as in any personal injury, can recover that which they have lost. We respectfully agree and didn't contend otherwise. The decision itself appears in tab 5 of the authorities bundle. The facts were fairly unusual and are set out in essence at page 826 in the head note. In short, the claim was brought by and for the benefit of Stanley Adset, the 70-year-old father of Richard Adset, who was aged 26. And he brought the claim on behalf of Richard's estate. Richard was unmarried, had no dependents, and had been killed in a road traffic accident. As the representative of the estate, Stanley claimed for Richard's loss of income in the lost years. Stanley was described as a rich businessman who ran 3 businesses, and family members, including Richard, held stakes in those businesses. Richard had done some work for 2 of them, but his main activities and interests were sporting and leisure pursuits. And if one looks at page 829, there is a synopsis of the relevant facts, and this is at page 108 of the the authorities bundle. And at point C, it is noted in these facts, which are said to be taken from the judgment, all the important decisions were taken by the plaintiff, that is the father, and Mr. Watts, and all the partners were rewarded either as salary or profit sums, which were most advantageous for the purposes of taxation. And then some way down the page between E and F, discussing the deceased, it is said, he was used to spending a great deal of money, and the impression was of a man whose work was less important to him than his pleasure. He was a keen yachtsman and a half share in a £10,000 yacht. He rode and he was fond of skiing. So the trial judge held that the son's income from his share capital in his father's business was not a recoverable element, since his death had not given rise to any loss in those circumstances. The estate would continue to earn the investment income from the shareholding. And my lord, this is stated, and the ratio is at page 842 of this decision, page 121 of the authorities bundle, between C and D. to my mind, said the judge, there is a clear factual distinction which the ordinary man would at once appreciate between earned income and investment income. Immediately before he dies, the deceased has lost his earning capacity, but his capital remains, and with it, its capacity, not his, to produce investment income. But such income that was attributable to Richard's work was deemed recoverable, even where it had been paid to him in share dividends. And we say that is the approach that ought to be applied in this case. Now,
Well, just before we leave ADSET, do you accept that 842C to F is all correct?
Oh, yes. We don't challenge that part of ADSET on the A part of that.
Yeah, that's really the heart of it.
It is, yes. That's the ratio. There were some unusual parts of this claim. So, for example, Richard the son also claimed for the loss of inheritance that he would have expected from his father, not the capital, but the investment income that would come from the capital. And the judge felt compelled to say that was, in principle, a recoverable loss, even though he found it repugnant on the facts of this case. But it doesn't really arise here, so I won't dwell on that. But there may be practical difficulties in cases such as ADSET, where there is no clear demarcation of how and why the income had been distributed. But we say that those difficulties can be met by a test which can be used to determine whether or not income derived from shares, or indeed any other income-bearing asset, should be recoverable in the lost years. And the appellant's proposed test is this. If the injured person can make a simple gift or transfer of the capital or other asset and the income it produces, then it may be deemed to survive death. But if he or she cannot make such a gift in those simple terms, then it should be considered a loss.
Isn't that a bit dangerous? Because it might be possible by testamentary disposition for a man to leave the share income which is being paid to him as part of his salary to his wife.
I'm sorry, I didn't catch that.
I said, suppose you had Mr. Head made a will in favour of Mrs. Head. Could he not have left to her that income which he was deriving from his shares in the company?
Well, lady, he could, but the problem with that is that without his input, and assuming that she then inherited 90% of the shares and effectively owned the business and all the profits from it, who would be left to run the business and make those profits?
Well, I understand that, but at the moment I'm trying to test your proposition that you can have a clear, bright line on whether something can be left to somebody or gifted to somebody. Yes. And I'm struggling with it.
Okay. Lady, I certainly see the point. But the focus of the proposed test is to determine without more, would things continue as they are? And in that case...
Sorry, to continue to answer my lady.
The position would therefore, we say, change, because that 90% shareholding will be held by somebody who wasn't involved in the business, who couldn't run the business, who couldn't turn the same profits, and would dramatically decrease in value. Maybe I accept the point, it may not be an absolutely bright line, but we say it'd be a good guide, and it would apply certainly in this case.
On the facts here, where the company was projected to continue profitable, so that the shares would continue to have value, is the point that in order to continue profitable, somebody would need to step up to the role, in effect, which Mr. Head had been playing. That might have been one of his sons, or maybe they'd have got in somebody else with entrepreneurial skills, but whoever that was would need to be paid remuneration commensurate with, broadly speaking, what Mr. Head had been taking from the business for himself, and therefore the business would not have been earning dividends, which would have gone to Mr. Head or his estate. Maybe everybody else has seen this ages ago, but I'm trying to work it out. But is that the point? And therefore, that even if it had gone to his sons, who presumably were his heirs, they would have earned it, as it were, in their own right, and not by way of inheritance from him. Is that essentially why you say that the continued profitability of the company doesn't matter?
My lord, yes. My lord, that's a much more eloquent answer to the one I gave to my leadership.
Very grateful to
if I can adopt that and hand it over to my lady, that's what I'd like to say. So yes.
Yes,
And so if one to follow that theme, if there were shares in a FTSE 100 company, if there were shares in ICI or Ford, which was the example that Mr. Head gave, you could simply transfer them. It would make no difference. But they weren't. What we submit is that these shares didn't have an independent earning capacity, which is precisely the point my lord was making. Or perhaps I'm taking it a bit further. That's where I was certainly going with that submission.
yes. Well, I'm struggling to understand what you're submitting, but there we are. That's very clear. Thank you.
But that's not what the judge did, and we can see what the judge decided at paragraph 117 of the decision that's again back in tab 9, and it's page 114. I've already drawn upon this paragraph briefly, but it's the next part where I rely on what the judge said. And I quote, "I have assessed the estimated future expected net profit to the EMSL before directors' salaries, tax and distribution of dividends at £580,000 per annum. After directors' salaries and tax are paid, 90% of what is left is attributable to Mr. Head's shareholding held by him and through Mrs. Head, and will continue to be attributable to Mr. Head's shareholding after his death, wherever he leaves those shares by testamentary disposition." My lord, that is the point I think you were making, and we say that was wrong.
All you say stemming from this misunderstanding of what the accountants were actually doing.
Yes. It starts with what the judge perceived to be a shared opinion, and therefore doesn't necessitate further inquiry. Because why inquire when the experts have agreed? We say is that the reality is that these shares were simply a means of distributing his income. It's a family business. He controlled 90% of the shares. He effectively controlled the company. It was him. He was the driving force. He made the decisions himself. And without him, those shares, we suggest, would be too strong to say worthless, but would lose their value.
So you can actually postulate a number of scenarios. You can have a situation where, as my Lord Justice Bean put to you earlier, a man starts up a company, it's very successful, he then takes a back seat, gets to the stage of retirement and is basically just reaping in the dividends. Then he becomes a passenger, so to speak, and there's no value left. So there's no lost years claim at all. On the other hand, you could have somebody who is the company, but even more so than Mr. Head. There's nobody else left there, like the one-man band that was, who for tax reasons becomes a company. And when he dies, the company goes, therefore very large claim. And here we've got something of a hybrid. Here we've got a man who's started up the company, who has built it into a multi-million pound turnover business, which is not going to disappear when he sadly passes away, because there are people to leave it to, but the company is going to be, to an extent, diminished by his absence. The extent to which it's diminished is quite difficult to work out, but his value is not zero because he's not a passenger. He continues to contribute to the profitability, and the profitability will inevitably go down when he is no longer around.
Yes, maybe, and the shares insofar as
Yes.
he holds them. That's the point that I focus on.
Yes,
Except that it-
because the earnings were taken into account anyway, so you're focusing on the shares.
Yes.
But it's that's not a criticism. I mean, it's obvious. So you say that the judge is wrong to, if you like, discount the shares altogether, on the basis that that's putting him in the same position as if he were contributing nothing.
And
But on the other hand, to say that the loss is all of the dividends from the 90% shareholding suggests to me that nobody else was contributing in it.
Yeah.
My Lord, I respectfully suggest it doesn't quite suggest that, because there were salaries being paid that are taken into account in the bottom line profit figure. So the salaries of all the people who were working for the company, limited as they were, and the other payments to subcontractors and the like, they reflect the value of those people in the business. And it's really about what survives, in a sense, and beg your pardon, what is lost, and what is lost for the claimant. So, my Lord, the position we placed at its highest was that all of this income, the retained profit, dividend share, the dividends and the salary, reflected his contribution. We maintain that position, but we accept that there are, as my lady has said, potential intermediary positions. And that's not a new case. That's just the height of the claimant's case versus the exercise that the judge was being invited, or we submit, should have carried out, if she didn't accept the full extent of the claimant's case.
But what material did the judge have to go on in order to get to an intermediary position? Because the judge appears to have thought that it was put before her as an all or nothing case, and that's really the force of Mr. Kent's submission, is that if a judge is faced with an all or nothing case, then the risk that you run is that you end up with nothing if you can't prove all.
Lady, yes. In submissions, I accepted, perhaps a little too grudgingly, that the shares might have a residual value. And my learned friend submitted that the salary that Mr. Head was being paid grossly undervalued his role. But we say there was sufficient material for the judge to make this determination. There was quite a lot of evidence about this, uncertain in a way because of the situation. So Mr. Head was asked about this at trial, and if I could perhaps take you to the supplementary bundle. Tab 1, page 30, I think. 30. Between E and F, my learned friend said, now sadly, if you're no longer able to contribute what you are contributing, can you think of anyone who might replace you? That is to say, an employed person or an incentivized person who might come in with particular skills to avoid this pitfall. He said, okay, well, I can't think of anybody in our company. No. And then he said, you need to go into the market. In his statement, if I can take you to that in the supplementary bundle, it's paragraph, so it's tab 7. paragraph 10, page 210. He said at paragraph 10, "My mind is sharp and I don't feel physically that bad at the moment. I do not envisage any immediate changes in my salary or share arrangements. I have no provision in my will for the division of company shares as yet. I need to take advice on this." So he was equating his contribution to the company with the shares he held and the salary that he drew. But when the judge was considering the intermediary position, we say that she had sufficient material. She had the reports of the accountant. She had their analysis of his contribution to the business. She had 5 years' worth of accounts. And there was, we say, ready-made example of what the judge could have done in Adset and West itself. And I've given the example in my skeleton argument at paragraph 78. Forgive me, it is up. Tab 3.
Yes.
I'm great.
78 you're citing from
78,
Adset
citing
and West.
Adset and West. And this, we say, is the type of exercise that the judge could and should have carried out. So the claimant's position at trial was that on the evidence, the full case was more or less made out. But that the full case encompassed a range, potentially, of positions. My lords, my lady, it's fair to say at trial we stuck to the case at its highest. But we say the situation really was no different to a loss of earnings claim in a conventional personal injury case. So the parties will present submissions from different ends of the spectrum. You can imagine a spinal injury case where the prognosis is uncertain. He or she, the claimant, may seek the whole amount of their earnings on the basis that they never work again. The defendant will say quite to the contrary, there's no reason why you can't make adaptations and work in full. The judge is not bound to make a decision on that binary basis. She was, we say, quite within her rights, and on the evidence she had sufficient material to make a determination. In the skeleton argument, I have suggested, for example, that she could have said that 10% of the share value would be transferred and be transferable. The question, and perhaps I can move on to it, is dealt with in proposition, my proposition 6, which is that the judge failed to consider what Mr. Head would lose. And I'll attempt here perhaps to deal with the question in a more complete way. The pleaded case was that Mr. Head had lost all the income from the business. And the parties took the following positions. The claimant submitted that his loss of income was everything which he could draw from the company, and contends that that was all of the income. The defendant's position, we say, changed, or at least slightly evolved during the course of the proceedings. In the defence, and that appears in the appeal bundle at tab 12, at paragraph 18.5, page 136. the defendant contended that there was a structural error in the claimant's case, and that structural error, one looks at 18.5 on page 136, was that the shareholding and associated income is one which will exist after his death and be available to pass on should he so wish. The position at this point appeared to be that because the income was derived from the shares as a class, they could not be recovered as a matter of law and principle.
Yeah.
And that was the basis on which we joined battle. The position in the counter schedule was slightly different. And if I can go to the supplementary bundle to take your lordships to that, tab 6. It's page 205, to which I refer. And the defendant, the respondent here, enumerated what it contended were the relevant principles at points 1 to 6 on page 205. And at point 1, the defendant said it's necessary to distinguish between the element of earnings properly attributable to the claimant's continued active participation in EMS and that attributable to the return on his capital invested in EMS, which is the point the lady was referring to. And the answer that the defendant gave to its own question appears at paragraph 1 at the bottom.
Well, just pausing there, there's nothing wrong with 1, is there? That's the correct approach.
My lord, yes. We submit it's the correct approach, save that one shouldn't dwell on the category, the labels. But the answer was given by the defendant at 205 and over to 206, where the defendant said this: it's apparent that the extracted profits leave a significant element of company profit not dispersed through a policy of prudent capital retention, and this retained profit is properly treated as part of the claimant's investment income and is therefore included in the projected dividend. So the position at that point seemed to be that the defendant was saying that retained profit was investment income and appeared to be allowing for, although not said in terms, appeared to be allowing for the possibility that dividend income would be recovered. In the opening note for trial, the defendant suggested that only the salary should be recoverable. And I'm still in the supplementary.
So back to square one.
Yes, back to square one. In the supplementary bundle at tab 4, at page 190.
Just looking at looking at the counter schedule before we leave
Yes,
that
yes,
to
yes,
the paragraph you've shown us, paragraph 1 of the defendant's case. And picking up the point I asked you about before, I mean, would one way of analysing that be to say that the remuneration for this notional replacement for Mr. Head could be treated as equivalent to the combination of his salary and the dividends he had taken, but that the money retained in the company would still be there for the benefit of the shareholders?
My lord, we wouldn't quite agree with that. Insofar as it related to money held within the company, that was, in essence, his past earnings, to which he would be entitled. And was an accumulation of the funds that he put into the company. So that wasn't what was being claimed.
I suppose it's all quite arbitrary anyway.
It is, my lord. It's because he controls
done
it.
on advice for tax purposes.
Right. And if one looks at the retained profit, actually the defendant's accountant, Mr. Ford, said that should be treated as prudent, and he certainly treated it as income that was accrued to the claimant. So it would slightly contradict the way in which the defendant's accountant approached it, and with which we agree.
So although you draw attention to this, as you're about to show us that the defendant changed his case,
Well,
which is always a good forensic point, I suppose. But basically, there's no logical reason why paragraph 1 should be any better than any other way of working.
No. Well, my lord, I show it because it perhaps explains the mistake that we say it was made, in that the parties were, to a certain extent, talking at cross purposes. We initially thought the case that we were meeting was that share income, share dividends cannot be recovered. This is slightly different.
Because they're not part of the loss of earnings.
Yes.
Because they're investment income rather than earning income.
Yes.
To put a label on it.
No.
So you thought that was the case that you had to
We
meet, and
did.
it wasn't quite.
I don't complain too much. There are time constraints in these cases. You'll see that he was diagnosed and we had a trial within a few months. And I resolutely don't complain about the way in which we presented the case. I'm simply saying that explains, to a certain extent, I say, the passage of some of the evidence.
There's quite a lot in both directions, not uncommon in complex PI cases, of you changed your argument as the case went along. But unless the raising of an argument is unfair because the other side can't deal with it, which doesn't seem to be the position here, the judges, it seems to me, had to reach a decision on the basis of the arguments as finally presented to her, whatever the history.
My lord, I respectfully agree. Which is what Lord Scarman said in Gamel. I've cited the passage in the skeleton argument. He said that the principles are clear, the application may be difficult, but the judge has to use the material available. And unless it involves outright speculation, it must reach determination. And we, of course, accept the judge wasn't bound to follow the claimant's case at its full height. But in circumstances where she had accepted, we say, that the claimant's value wasn't accurately measured by his salary, it wasn't appropriate to stop there.
Is this a convenient point to discuss the Blamire and Cumbria approach which the judge refers to, which Mr. Kent raised? Or if you're going to come to that later, then do.
My lord, I don't really propose to say too much about the Blamire approach. The Blamire approach would simply be, if the judge had felt it appropriate, a recognition that she wasn't able, on the facts and the material she had available, to make a multiplicand. The Blamire reflects loss of earning capacity, where essentially the material isn't precise enough to make the kind of calculation. And if the judge had felt that was the position here, we respectfully submit it would have been open to her. Of course, the material that she would use in that calculation would be precisely the material we say that she was presented with, which is the accountant's report. So we say it doesn't really take the position, it doesn't take the point any further.
Well, I imagine Mr. Kent raised it as recorded in the judgment. And Blamire and Cumbria is actually a much more straightforward case than the present one.
Yes.
The Court of Appeal were saying there will be cases in which the predictions are difficult or the calculation is difficult. Don't throw up your hand in despair. Do the best you can. See her, Lord Scarman and others in the two House of Lords cases. But here the judge seems to have said it's all very difficult, but I'm not convinced that any part of the pleaded case has been proved. Therefore, never mind Blamire and Cumbria, the answer is 0.
My lord, in circumstances where we say, although not an easy exercise, there was sufficient material. We obviously, well, my lord, I hope for obvious reasons, we didn't press the Blamire award ourselves.
No.
We were rather hoping we had made our full case, but the full case encompasses a range of others. So at trial, the judge was faced with those two very different cases, and the question posed was whether Claimant had lost all of his earnings or whether it was limited to his net salary. Now, the appellant contends that the defendant's position and what the judge found ultimately was wrong and ought to have been rejected for two, we say, powerful reasons. Firstly, the judge accepted that the arrangement was in place solely for the purposes of tax efficiency. His salary was up to the threshold of the income tax bracket high level, and the judge accepted it was done purely to minimise tax liability. Secondly, my learned friend, in the course of submissions, accepted that Mr. Head's salary didn't represent his worth to the business. And for your Lordship's note, it's in the supplementary bundle, tab 2, page 116. Just go briefly to that, if I may. My Lord, forgive me, I've got the wrong reference in my notes.
Mysterious reference to Mr. Justice Fraser.
Mr. Fraser, he made a curious appearance, unexpected arrival. So. I'm being told it's page 116. I beg your pardon. Yes, it's opposite C. My mistake. Mr. Kent said at the other extreme is someone who extracts everything by way of salary, and there is somewhere in the middle. I entirely accept, and this is another point I will address in due course, that Mr. Head, if you look at his salary, that grossly undervalues his role. In other words, if he was not a shareholder in the company and had been brought in to do what he undoubtedly does, he is paid far too little. So conversely, why do we say the claimant's case that he had lost all of his income was right? And maybe this perhaps addresses the point that you asked me earlier, and I didn't really answer very well. but we rely on those first 2 points, of course, as being why the claimant's case was right. But we say this. Firstly, the claimant's income was closely, even inextricably linked to his working capacity. It was a family business which he controlled, and the use of dividends was solely a vehicle for distributing that income. He was handsomely paid because he did the work, not because he held the shares. Secondly, Mr. Head's own evidence showed that he considered the division of shares to be a reflection of his contribution to the business. And that can be seen in paragraph 10 of his witness statement, which I've already taken the court. What he was supposing was that as he grew older, as he did less work, he would have to distribute some of his shares. But he felt physically fine at that time and he hadn't anticipated it in the moment. So thirdly, for the reasons given in the judgment, the income was a fair reflection of his services. As the judge said, the business is him, and with him at the helm, it continued to produce the healthy profits we have seen. There was also the very powerful evidence that the judge accepted about his central role in the business. And my Lord, Lady, you may recall the evidence that Mr. Head gave about his scrutiny of contracts and how one line in a contract can be the difference between losing £200,000 or making £200,000. He was describing something that was very personal to him and his contribution, which the judge appears to have accepted. So on the face of it, we say that the income that the claimant derived from the business was an entirely reasonable reflection and recompense for his value to the business and his efforts. And there was no suggestion by anybody that the income claimed was anything other than commensurate with the value of his work. Fourthly, we say a repetition of something I've already said. It was a mistake to treat this by way of category, and I've given the examples of the shares in the blue chip company versus this company. And fifthly, we say the expert accountants who had seen and analysed the background financial documents both naturally assumed that the claimant's income was related to his working capacity. Mr. Forth, in his projections of Mr. Head's but-for income, used multipliers in their assessment, which he discounted for contingencies other than mortality, in accordance with the approach given by the Oldham Committee. Those discounts were necessarily for the possibility that Mr. Head would be unable to work for unrelated reasons. We say that's an example of an assumption being made, and we say a fair assumption that this was his working loss. And the projections of both accountants explicitly were calculated on the premise that as Mr. Head's involvement in the company decreased, so too would his shareholding and his income. And this was described by the respondent's expert, Mr. Forth, as being intuitively reasonable. And the reference for that is paragraphs 4.23 and 4.24 of his report, which is in the supplementary bundle, tab 11, 303. Now, we of course accept that this is not self-proving, and but the claimant was a person who was described by the defendant as being conspicuously a man of integrity and honesty, and he had presented his claim on that basis. That's what he said his loss was, and that's how he calculated his own value to the company.
I suppose one contingency which neither the accountants nor anybody else would have taken into account would be the effect on the company of the coronavirus pandemic. Which would, if it's done the same to this company as to practically every other business, will have knocked a big hole in the figures.
My Lord,
Do we just ignore that if we're trying to work out what the right award would be?
My Lord, I submit you ought to ignore that. The assessment has been, we are considering at this stage what assessment the judge ought to have been making. It's not something that few people could have foreseen, and equally we have no evidence as to what the effect on the company actually was. So, they are contingencies, but the contingency that was applied here was, we respectfully suggest, was about what Mr. Head would do in the company, what his earnings might have been.
You say Mr. Forth's approach takes account of, for example, the possibility that Mr. Head might suddenly develop very bad arthritis and no longer be able to get round to his clients, or he might have a stroke.
Yes.
And be incapacitated through other reasons which had nothing whatsoever to do with his diagnosis.
Precisely, lady. It was more likely he was anticipating that than the coronavirus in April 2019. But I take the point.
Well, that sort of thing is built into the Ogden tables, isn't it? I mean, the more expectation. Sorry, not the Ogden tables, but the calculation of loss of future earnings. You first find out life expectancy, but then you have to discount somewhat. Maybe in the case of a claimant in poor health, you have to discount more, but you have to discount for the contingencies of life, which might include the kind of thing that my lady referred to.
And my Lord, that's what the accountants were doing. They were analysing the customer base. So in a sense that it's not something that they foresaw, but it's the kind of issue that they will be taking into account, albeit not in precise terms, obviously.
No.
So, my Lords, we say in the light of all of that, the claimant's case was plausible, it was supported by evidence, and the judge had no real reason to reject the claim advanced in that way, and didn't adequately explain why she did so. In fact, the judge never considered at any point what proportion of the claimant's income was a reflection of his work, and we say that was a failure. And the ultimate difference between the parties, we say, is one of substance and form. So when confronted with the seemingly opposite cases, we say it was possible for the judge to test the validity by looking at the underlying assumptions or necessary inferences from each of those cases. So the claimant's case was in effect what my Lord put to me, which is that if he wasn't there, someone would need to be there. And it wouldn't be done for free. They would expect a stake in the company, they would expect a commensurate share. But the defendant's case, conversely, amounted to saying, was on the assumption that if EMSL continued as a going concern after Mr. Head's death, that those who ran the business would not be reimbursed for their work for a period of 23 years, and that they would continue working in order for Mr. Head's beneficiary, the estate, to extract 90% of the profits. And we said that's not realistic. However, if the judge was not minded to accept either case in full, we submit that there were intermediary positions, and it's possible to outline a few. What wasn't possible, what wasn't permissible was simply to adopt the defendant's case in circumstances where the judge clearly did not accept the fact.
All right. What alternative approaches do you say would have been open to the judge?
Well, my lord, first, the court could have assessed the percentage shareholding that the claimant or his estate would need to give away, either to his sons or on the open market, to incentivise someone and to reimburse them for performing the role that he performed. So it could be a transfer of the shares to somebody else. Secondly, the court could have measured the loss by capitalising the claimant's future revenue stream from the business, which had been done by the accountants, and deducting from that figure, say, the residual value of Mr. Head's shares in some kind of fire sale after his acknowledging his impending death. Or thirdly, there was the example that I've given of Adset West, where the judge does the best that he or she can based on the material that's available. In Adset West, despite the findings that I took your lordship's relation to, that the son was a man who was given to leisure in his sporting pursuits, the judge came up with a figure of 50-50. And if that approach were taken in this case, we say there is clearly no comparison with the contribution that Mr. Head made. So the judge had sufficient material to carry out an assessment. She had the business accounts for 5 years, along with a detailed analysis from the experts. And ultimately, we say the best indicator of what Mr. Head contributed to the company was his income, his earning capacity, and what he was entitled to draw from it.
You say one approach, the first one you mentioned, would be what percentage shareholding should be given away to incentivise or reimburse a replacement. Do you have any submission as to what the percentage would have been, or are you just leaving that in the air?
My lords, I'm slightly leaving it in the air. In the skeleton, we suggested, say, a 10% residual value of the shares, and we would say something similar, that it would be necessary to give away most of these shares, the vast majority of these shares, to provide the same kind of incentive.
But to provide incentive is the wrong test, isn't it? It's to replace Mr. Head.
My lord, yes. What I'm seeking to do is to draw upon what would happen in the real world if this business were to continue. It wouldn't be, we say, realistic to assume that the estate, whoever held those shares, could continue to drain 90% of the profits, but provide nothing in return.
Well, you've only got to put yourself in a sort of dragon's den situation and see what the entrepreneur would want to take for a stake in the company in order to come in and take it over in the absence of Mr. Head. It might well be prepared to take less than otherwise because it's already up and running as a successful business. But then there would be some sort of hefty discount for the fact that he's made all the personal contacts and you've got to make those all over again. So certainly wouldn't be less than 50%, I would have thought, but it might be more, it might be considerably more than that, but it certainly wouldn't be less than 50%.
No, we agree. No, while I still leave the figure in the air, we say it would be the vast majority of these shares.
Yeah.
But Mr. Kent says none of these alternatives were placed before the judge. They were sort of going for Chicago or bust. I mean, you know, with 4.4 million, and if you don't accept that, we're not really interested.
Well, no, I wouldn't quite put it in that way. It is true that the claimant presented the case at its highest and stood by that case. But in submission, I accepted perhaps too grudgingly the possibility that there was some residual value that would remain rather. My Lord, these are possibilities that we are drawing upon and seeking to explain were available to the court. But I accept entirely, of course, that we maintained our full case before the judge.
Well, suppose that you have persuaded us by the end of the case, notwithstanding what Mr. Kent is going to be saying, that the judge got it wrong, but we are sceptical of the case as presented, 4.4 million. What are you asking us to do?
Well, my Lord, I submit you have the material, if your Lordships took that route and decided to do so, to make an assessment. It would necessarily be an approximation. But on the findings of fact the judge made, I respectfully submit it would be possible, albeit rough and ready. An alternative, of course, would be for remission to the judge, with some guidance as to how the case should be assessed. My Lords, in that hypothetical scenario, we would submit and prefer the former, but obviously the latter is a possibility. I'm conscious of the time. My Lords,
Yes.
I don't want to steal my learned friend's time either.
Well, if you've reached the point where you'd like a lunch break to think about it, and then come back, then that's fine. Is there ground to cover which you know now that you have yet to cover?
My Lord, I'm almost at the end. I was going to take the court through a couple of examples in the authorities where the...
All right. Well, do that, and then we'll break off, subject to your coming back and say you want another 5 minutes because it's something you haven't thought of.
Perhaps if you're thinking about my Lord's question, namely, suppose the judge got it wrong, but we're sceptical about your full claim, what should we do? You might add this variation. What should we do if we remain doubtful, or if Mr. Kent persuades us that the alternatives you've suggested were not really in play below?
My Lord, yes. Well, my Lords, I make the tentative suggestion that where income is potentially bound up in working capacity and as a return on capital, and where it's difficult to separate the two, the courts have tended to give the benefit of the doubt to the claimant. An example of that would be ADSET itself, where the 50-50 split doesn't seem to reflect the judge's view of the entirety of the evidence. But there are other examples, and if I could just, I would attempt to do this very quickly. Wooden Benthall is one.
Yes.
It's tab 7 of the authorities manual.
And this is fatal accident.
It's
not
fatal
lost,
accident. Yes, there is a qualification to be made that it's a fatal accident. So in Wooden Benthall, the facts appear sufficiently from the head note. It was a claim brought by the dependents of a farmer. He had an interest in a 300-acre farm, which he held together with his partners. His partners were his brother and his parents. And his income was tied up with the asset, but also related to mainly to the work that he did. The trial judge made a finding based upon the income that he was entitled to draw from that business, notwithstanding that it also related and was derived from his interest in the capital. And I would just like to take the court, if I may, to the decision of Lord Justice Beldam, page 344 of the report, page 167 of the authorities bundle. The appellant in this case submitted that the trial judge was wrong and ought to be making a hefty deduction because much of this income could be said to derive from the capital interest in the farm. And at page 167, page 344, we can see here in the first full paragraph of text, where beginning with the evidence clearly showed. The evidence clearly showed.
Sorry, where?
I beg your pardon, my lord. It's in the first block of the full.
Oh, I see. Yes, got it.
The evidence clearly showed the assets were substantially increasing in value as a result of the deceased's hard work. Mr. Livesey stated that the general principle which he relied upon was one of general application, that the law did not permit double recovery. And then moving down slightly towards the end of this paragraph, it's not irrelevant that if Mr. Livesey's argument is correct, the value of the deceased's work in the farm was worth less than the £10,000 per annum, and he was a man admittedly of well qualified experience and of exceptional ability in agriculture. And then moving on, my lord, my lady, to the next paragraph, beginning with "to make good." Lord Justice Beldam said, "To make good the claim that the dependency upon which the award of damages was based included a sum which represented a return on the assets employed in the farming enterprise was, on the basis of the accounts produced, a difficult task. And it has to be said that it was never attempted by the appellant. If the figure of £20,000 per annum was taken as a reasonable salary for the deceased and his brother for their work in the enterprise, and this was never challenged, the return on the deceased's share of capital employed in the 3 years preceding his death was as follows: was less than 10%. And my lords, over the page, page 345, 168, halfway down, Lord Justice Beldam thought it was relevant that there was no evidence of the return on capital employed after salaries had been taken into account in the figures to which I've already referred, and therefore no basis for saying that by disregarding the value of the assets, the dependents were receiving compensation for the portion of the dependency which they had not, in fact, lost. I would also refer your lordships to the judgment of Lord Justice Staunton in this case.
This is the passage set out in the head note.
Yes. It's,
where the income in part derives from the work of the deceased, the court must determine how much the dependent has lost because the deceased is no longer alive and able to work, and how much of the deceased's income was derived solely from capital that the dependents have inherited.
Yes. But there's a gloss which I say that Lord Justice Staunton accepted, and it appears at page 349, 172 of the authorities bundle. And perhaps I could ask the court just to read from "One then turns to this case," which is the passage I relied upon.
In the present case, if Mr. Head had died before the case came to trial, which could well have happened, the basis of calculation in the claim as presented would effectively cease to exist and be replaced by a fatal accidents claim on behalf of Mrs. Head and her family. It would be surprising if the loss were hugely different, but maybe it would. Have you ever thought about what the difference would have been in those circumstances?
Well, we have, yes.
Yes.
Especially after the result of Judge. My Lord, that can partly be answered, I suppose, by the decision in the case of Ricks, which is the last authority in this bundle.
Right. Tab 15.
Tab 15. Before I move on, if I may, just the point I was seeking to draw from this was that Lord Justice Staunton clearly thought it relevant that although there was some of the income could be said to be derived from capital, he clearly thought it relevant to look at the actual worth of the person doing the service. And that's the simple point I made. But
Yes.
tab 15 is a case of Ricks and Paramount shopfitting, I almost said shoplifting, which appears at 255, tab 15. A case which in some ways is remarkably similar to this case, not least because my own friend was in that case. Mr. Ricks ran a successful business, and the factual background is set out at paragraph 12 of this case, judgment, I beg your pardon, at 257, where it said Mr. Ricks was plainly a remarkably talented and dedicated business, from very small beginnings and starting at the age of 21 in 1977. He built up a business that was originally concerned with installing kitchens and repairing kitchens and bathrooms, and the scale of the business increased. And then, if the court turns over to paragraphs 18 and 19, it is said that Mrs. Ricks was a major shareholder in the company and drew a salary, but did not work in the business, and never has done. She had a shareholding which produced dividends and drew a salary. This was not to reflect her contribution to the business, but was done on the accountant's advice, and was a tax-efficient way of taking money out of the business. There was no suggesting anything was improper. And then in paragraph 19, at the time of his death, Mr. Ricks owned 40% of the shares in the company. Mrs. Ricks owned 40% of the shares, and their sons, Jonathan and Adam, owned 10% each. After Mr. Ricks died, Mrs. Ricks inherited her husband's shareholding, so she currently owns 80% of the shares. There is a striking factual similarity, we say, with the present case. The difference was that Mr. Ricks had died by the time of the trial. And if one looks at page 259, paragraph 24, it is evident that after his death, the business had gone on to do better than before and had made greater profits. Now, Mr. Justice Kavanagh was faced with the argument that there was no loss because after the death of Mr. Ricks, the business had continued to thrive. And if one moves forward to page 262, my lords, my lady, you'll see there from paragraphs 41 through to paragraph 42, we dealt with and considered the decision of Wood and Benthall, which we've just been looking at. And paragraph 43 cites McGregor on that decision and what the views of that text are. And then if the court can move forward to page 269, paragraph 64, the foot of that page, we have there submissions from the defendant, my learned friend, in fact, making similar points that he made in this case. And perhaps I can ask your lordships to read 64.
judge's conclusions at 66, you would say, are no doubt
Malady.
similar to...
Malady's ahead of me, yes. 66, and also, in fact, 83.
All right.
Which is over the page, it's 270.
Then at 92, we actually see the judge doing the exercise of separating out the income which was derived from capital from that which was derived from labour.
Malady, yes.
Yeah. 96 seems familiar. Right. What else would you like us to
My Lord,
read?
I have reached
Yes.
the end of what I was going
Good.
to say to your lordships.
Thank
I will
Thank
bear
you
in
very
mind
much. Well, we'll break off here. We'll come back at 2:10. If you want 5 minutes, then of course you may have it, and then we'll hear from Mr. Kent.
Right.
Yes, that's right.
I'm going to set it